to the court, the executive council, academic council, and such other authorities. We find as far as the authorities are concerned, the Lord Rector, the Governor General are not part of the authorities. That is, now, my Lord, 23 has been read, but I'll quickly go through it. The court shall consist of the Chancellor, Pro-Chancellor, and the Vice-Chancellor for the time being, and such persons as may be specified. The proviso, my Lord, is important. That is in the first phase. Provided that no person other than a Muslim shall be a member. 23(2). The court shall be the supreme governing body of the university and shall exercise all the powers of the university not otherwise provided by the Act, statutes, and ordinances. It shall have the power to review.
Mr. Dawat, just one thing. The proviso, when it says no person other than the Muslim shall be a member thereof, is only restricting itself to the members, not to the others.
That's right, my Lord. That's the point, my Lord. As far as the composition is concerned.
Composition is concerned, because whether members will include the Chancellor, Vice Chancellor, not strictly. Because members will be.
No, they're all members.
They are all members. And
Lord, because they become members of the court, they have to be Muslims, my Lord. Because members of the court will only be Muslim. So these persons will, by their very nature, have to be Muslims.
So what you are saying is the proviso makes it mandatory that everyone, right from the Chancellor to the Vice Chancellor and other persons, will be Muslims.
Yes, my Lord. Yes, absolutely. And that is how it works out, my Lord, in the first phase and post 1981. Now, my Lord, 3 has not been read out properly, my Lord. 2, I was pointed to have the power to review the acts of the executive and academic councils. So there is a reviewing part, my Lord, in the court. Then, my Lord, direct that necessary action be taken by the executive or the academic council, as the case may be, on recommendations by the Lord Rector. So the Lord Rector is somebody who makes recommendations, and they will be considered by whom? The court. Lord, 3 is very important, which has not been read out to your lordships. Subject to the provisions of this act, the court shall exercise the following powers and perform the following duties, namely, of making the statutes or amending and repealing the same. This is a very important power as far as number C, of considering and passing resolutions on the annual report and annual accounts. That's the financial power, my Lord, to consider. Of electing such persons to serve on the authorities of the university, and of appointing such officers as may be prescribed by this Act and statutes, of exercising such powers and performing such other duties as may be conferred or imposed by the Act and other statutes. Now, this is an extremely wide-ranging power in the court. And this, my Lord, 23(3 is operative throughout, my Lord, the period, even in phase 2. '81, my Lord, there's some dilution, and then, my Lord, it's restored in '81. Now, my Lord, the Executive Council, my Lord, shall be the executive body of the university. Then 5, my Lord, the Academic Council shall be the academic, and that, my Lord, is not relevant to the court part. Let me take your lordships, my Lord. In 28, where the first statutes, my Lord, may be amended, that's subclause 2, may be amended, repealed, or added to by the statutes made by the court in the following manner. So here, once again, my Lord, the court has a very significant function. That is in 28, subclause 2. And then the following manner is, the executive may propose to the court the draft of any statute to be passed by the court. So the draft comes to them and they decide whether it should be passed by the court. Such draft shall be considered by the court at its next meeting. The court may approve such draft and pass the statute, or it may reject it or return to it to the Executive Council for consideration, either in whole or in part, together with any amendments which the court may suggest. So here is an extremely significant power in the court. The nerve center, my lord, in the first stage and the third stage, 81, is quite clearly, my lord, the court and nobody else. Huge power, my lord, as far as statutes are concerned, huge power as far as ordinances are concerned. Then, my lord, if I may take you. Now, the proviso here, my lord, in section 28, that's PDF 12, provided that no statute dealing with instruction of Muslim students in the Muslim religion and theology shall require to be submitted or approved. That is an exception that is made out in the proviso. Then, my lord, if I may take.
But the only point
Sorry?
they had emphasized was C says that no statute, no new statute or amendment or repeal shall have any validity unless it has been submitted through the visiting board to the Governor General in Council.
Yes.
Now, significantly, this clause C does not refer to the rector.
That's right.
It refers to the Governor General in Council.
It
So
refers
really
to
the rector was to be the Governor General.
Not in any case what we are.
So it brings in an outside body, namely the Governor General, who has the power to approve. I mean, it's a prior approval of the Governor General.
Yes, ma'am.
So-
But then it comes to the court, and the court is the deciding body.
So therefore, overriding power to virtually approve any amendment, repeal, whether there should be a repeal of a statute, so on and so
But
forth.
not to initiate. Eventually, that is there, my lord. And as I had indicated earlier, my lord, these particular are supervisory functions, and in this case, as your lord points, my lord points out, a decision-making function as well. The proviso, my lord, your lordships, which I pointed out, is an extension of 28 2C, provided that no statute dealing with the instruction of Muslim students in the Muslim religion and theology shall be required to submitted or approving. So this is a huge exception that is, my lord, there in the proviso. So the Lord Rector, my lord, has no, my lord, function as far as Muslim teaching is concerned. Now, my lord. I'm going to forget.
The first statutes are by the Governor General in Council and no amendment can be made without him.
Has to be.
No, it has to be.
We can reject.
Yes.
We can reject.
No, without him.
Okay, the statute versus the other body being released.
He is the complete source of
Are you saying?
statute and ordinance.
Disallow or remit? That's fine.
Now, my lords.
And actually, this act was made, my lord, under the 1909 Council, not 1919 Act. Because the 1919 Act came into force on 9th February 1921 after the first elections. So the Council Act was continuing, my lord, and the council was nothing but the officials and a few nominated members.
So who enacted this act then?
Governor General in Council under the Act of 1909.
Oh, 1909.
Indian Council Act 1909. So though the Government of India Act is of 1919, it came into force after elections on 9th of February 1921.
In fact, it says that passed by the Indian Legislative Council and received the assent of the GG on 14th of September 1920.
The council was earlier also there, but this diarchical system came later.
By the 1919 Act.
And therefore, by rules, my lord, both these institutions, BHU, and they were kept with the Governor General in Council. And rest were transferred, education was transferred to the provinces by rules.
My lord, we are not denying that in the imperial statute, my lord, this overriding power with the Governor General existed, as your lordship.
Also reserved.
We're not denying that, but it doesn't take away, as we'll explain further, my lord, it doesn't take away from the power of the court as a proposing body or otherwise. So the initiation, my lord, in effect comes from the court. Now, my lords, I come, my lord, now to, no, I don't.
Just see
My lord, kindly come to the statutes on PDF 16.
Just see page section 30 ordinance or the section 30 or the power to make ordinances.
Which section was your lordship?
Section 30.
30. The Executive Council, my lord, I've marked it, or in academic matters, the Academic Council may make ordinances. I'll tie this up, my lord, when I read the statute.
And then 30 clause 3.
No new ordinances or amendment or repeal of any existing ordinance shall have validity until it has been submitted through the court and the visiting board, which may record its opinion to the Governor General and has obtained the approval of the latter. So, my lord, here is an important aspect that comes through the court.
And 30 clause 2 says the first ordinances will be as framed by the Governor General.
Yes.
And no new then can be made without it.
That was an interim measure, my lord, the first ordinances. We're now looking at the change and who had the power. The power, my lord, here is through the court and the visiting board. Now, the visiting board, as I'll show to your lordships, my lord, that provision has been deleted later on. Now, my lords, 31. The authorities of the university may make regulations. And who are the authorities, my lord? The authorities, my lord, that have been mentioned at PDF 11, my lord, in section 22, which I've already read out to you. And the authorities here are the Chancellor, Pro-Chancellor, VC, Pro-VC. The court, yes, of course. I've already indicated that they'll be appointed and elected. I've already indicated that. My lord, I don't want to go into it further. Then, my lord, 31.1, my lord, on PDF 14. The authorities of the university, and I've indicated who they are, may make regulations consistent with the Act, statutes, and ordinances. The Governor General, my lord, doesn't come under the authorities of the Act. And then 31, my lord, sub-clause B in 1, providing for all matters which by this Act, statutes, or ordinances shall be prescribed by the regulations. Then, my lord, every authority of the university shall make regulations providing for the giving of notice to the members of such authority, dates of meetings, and of the business to be conducted, or keeping a record of the proceedings. So, my lord, it is the authorities that become very central. And when I read the statutes, it will become clearer. 33, my lord, I've just mentioned 32. Said admission of students, my lord, shall be made by an admission committee consisting of the Pro-Vice Chancellor, the principal of an intermediate college, who shall be selected by the Vice Chancellor, and such other persons as may be appointed by. Here, my lord, it's without the reference to the external bodies of the Governor General or the visitor or rector, as the case may be. Then, my lord, section 33 on PDF 15. So, my lord, there is some overlap, residuary power in the governor. There's no doubt about it. We're not saying that. But the mobilizing factors remain the court. And then 33, my lord, that is on PDF 15. All arrangements for the conduct of examinations shall be made, and all examinations shall be appointed by the Academic Council in such manner as prescribed by the ordinances. So, my lord, it is the entire administration moves in, apart from that residuary power that your lordship had pointed out. And then what follows from these powers, my lord, is explicated in para 50. That is the right to appoint, the right to governing body, etc., etc. And TMA Pi makes this abundantly clear. Now, my lords, statutes. Why do you want to say it? Now, my lord, the vice chancellor, as I've shown to your lordships, is appointed by the court. I've already done that. Now, kindly come to PDF 17. That is statute number 3. The vice chancellor shall take rank in the university next to the chancellor and pro-chancellor, and shall be ex officio chairman of the executive council and academic council. In the absence of the chancellor and pro-chancellor, shall preside at convocations held for conferring degrees. Then there are certain emergency powers, my lord. Then, my lord, your lordships may kindly come to the treasurer, my lord, in statute 5. The treasurer shall be appointed by the court on such conditions and for such period as the court may think. So the court, my lord, comes in as the appointing body and as far as the terms are concerned as well. Then, my lord, you come to statute 6 relating to the registrar. The registrar shall be a whole-time paid officer of the university appointed by the court. So all these appointments, my lord, that are crucial to the administration are in fact appointments by the court. Now, my lord, and the registrar's functions are. Now, my lord, I come to the very important aspect of statute number 7. The following of officers shall be appointed by the Executive Council on the recommendation of the Academic Council. That's the proctor and the librarian. This is an important internal part of the administration in which that overall vetoing power is not there. Then, my lord, I come to statute 8, which is absolutely fundamental. Finally, first come, my lord, as to who are the ex officio members. Now, kindly read the ex officio members, my lord, along with 23 provisions. Because once they become members of the court, they automatically, my lord, are Muslims. So who are they, my lord? The chancellor, pro-chancellor, vice-chancellor, for the time being shall be ex officio members. But by virtue of being ex officio members, they must necessarily be Muslim if the proviso to 23(1), my lord, is to be taken into account. Now, my lord, kindly see foundation member.
As a matter of fact, they've been always Muslims?
Sorry? Yes.
As a matter of fact, they've been always Muslims?
Yes. My lord, I'm first dealing with the de jure argument, and we'll come to the de facto later. De facto, as has already been pointed out by Mr. Shadan Farasat, my lord, that argument has been spelled out, therefore I don't need to repeat it. Now, my lord, kindly come to the foundation members. Of the 180, my lord, 124 were foundation members. Necessarily had to be Muslim. To read it, my lord, along with 23 proviso. And this is 124 at its inception. Naturally, they continued to be less and less as we moved on. So 124, my lord. Now, my lord, the next one is life members. This is all part of the court, my lord, and that's the important part. They all have to be Muslims. Then, my lord, ordinary members shall be elected or appointed as follows: 10 persons to represent states in India. And these 10 persons also, because they are members of the court, they have to be Muslims. Then, my lord, 60 members who make a donation, as long as they are.
Just 1 second.
Affectionately, the important point in statute number 8 is they all have to be Muslims.
Statute 8 says that the court shall consist of the following members.
That's right.
The proviso to 23(2) says no member of every member of the court has to be a Muslim. Therefore, that will apply to every person who is defined to be a member under Statute 8. That's
because earlier your lordship did indulge is not the right word, my lord, in some mathematics about 20, 34, etc. Actually, all of them, every single one of them will have to be a Muslim.
De jure. I mean, that's apart from Shadanza.
I'm on de jure, my lord.
Yes.
De facto has been argued, and to the extent I want to refer to it, my lord, I'll refer to it. Now, my lord, therefore, the 10 persons to represent states by virtue of the proviso will have to be Muslim. Then, my lord, 60 persons elected by persons who make donations. My lord, by virtue of the proviso, they will have to be Muslim. Then, my lord, we come to 20 persons elected by the Standing Committee of the All India Mohammedan Educational Conference from amongst its own members, not less than 10 of whom shall be members who have engaged at least 5 years in teaching. They have to be, my lord. Now, 7, my lord, is very important because all members of 15 members, that subsection, that's 7, 15 members to be elected by the academic council from amongst its own members. Who will they be, my lord? They will be Muslims. By virtue, my lord, of going into the proviso read with Statute 8. So predominantly, my lord, across the board, they have to be Muslim in that first phase. Therefore, my lord, 15 of the persons in the academic council has how many? 28. Therefore, 15 of those 28 in the academic council will necessarily have to be Muslims. Then, my lord, Statute 9. The members provided for in classes 1, 2, 3, and clause 1 of class 4 shall be members of the court. Now, my lord, kindly come on PDF 21. The Executive Council shall consist of not more than 30 members. Vice Chancellor, Pro-Vice Chancellor, Principal, Intermediate College, who shall be elected by the Vice Chancellor and the Treasurer to be ex officio members. But here, my lord, subclause 3 is important. That's Statute 15(3). 6 other members shall be elected by the Academic Council and 20 shall be elected by the court, of whom not less than 7 shall be residences from outside in the United Provinces. May I come to Statute 16, my lord, which is important. I've already indicated the composition, my lord, of the Academic Council will necessarily 15 of them. Then, my lord, if your lordships will come to statute 16 in PDF 21. The Executive Council shall, subject to the control of the court and to the acts, statutes, and ordinances, administer the revenue, properties, regulate the finances, and so on. So the executive court will be subject to the control of the court. Then, my lord, footnote 3, want what read? Yeah, I've read that. 15.3, 6 other members shall be elected by the academic council, and 20, that's important, I'm sorry, you were right. And 20 shall be elected by the court. So, my lord, there are 20 there that shall be elected by the court. Then, my lord, 16 I've read under the control. Now, my lord, kindly come to the academic council. I've already indicated that 15 members of the academic council are part of the court, and therefore necessarily, my lord, those 15 in the academic council will have to be Muslims by virtue of the proviso. Now come, my lord, to statute 17. The academic council shall consist of vice chairman. He is a member, my lord, of the court. Librarian and proctor by the EC. Then, my lord, kindly come to PDF 22. 2 persons elected by the court. Now we add to these the 15 members, my lord, which we have indicated, my lord, who would be part and parcel, my lord, of the court and therefore members. Then, my lord, various, I don't think it's relevant directly to the control, but the departments of studies, your lordship has seen, we've already pointed it out, Sunni theology, Shia theology, and so on. Now, my lord, come to statute 20, PDF 23. 20 is very, very important, my lord. Subject to the general control of the court, all appointments in the teaching staff shall be made by the Executive Council from a list of persons recommended as suitable, therefore, by the Committee of Appointments, consisting of Pro Vice Chancellor, Chairman, Department of Studies. So here, once again, my lord, what we see is subject to the general control of the court. The foundation members, my lord, has already been shown to your lordships on PDF 24, 25, and 26. Well, all the way through. They're all Muslims. So, my lord, what I'm indicating to your lordships, although 51, my lord, which was said to be just to bring it up to date with the Constitution, 65 was an emergency measure, which is rectified to some extent in 72 and 81. And in 81, my lord, there is a full restoration as it was in the 1920s.
Can we go briefly to the 1951 now, so that we can see what is the next?
Just show me.
The evolution is then complete.
My lord, I cheated a little, my lord. I'm relying on this. It was easier for me.
I noticed that you are not on your iPad.
No, it will go further and further, my lord. I told you he's my guru. If he can do it, I can do it.
One of my cousins was in the.
Well, the solicitor had indicated a chart. Now, let's see the statute itself. Good. I'm sorry. shown everything.
4A or 2?
It's also there in volume.
Year after 5 years, and they were eligible for re-election.
That indubitably, my lord, indubitably. So this is the 51 Act.
Now, 1951 is volume 4A.
Did your lordship want to see the 51 Act as well?
Yes, I think we
Yes,
should
certainly.
just have a flavor of what
Certainly.
happened there.
My lord, what is the PDF
This is
of?
page 4A, the volume 4A, page 90.
4A, page 91. Now, my lord, an act to further amend the Aligarh Muslim University. Act is called the Amendment Act, my lord. 30 and 31 shall come into force at once, section, and the remaining provisions of the act shall come into force on such date as these are, my lord, machinery provisions. Then, my lord,
I'm sorry, I missed out the page number, PDF page number.
Page 90.
page 90.
90, page volume 4A.
इसमें क्या कहे दिखाना है बता rapid fire. Then, my lord, your lordships will see section 2 of that act. No, nothing much there.
Section 5
Yeah.
needs to be looked at.
Page 91.
91.
Back up.
So, my lord,
T1.
91, section 5, which is really the section.
Pending section 8. Classes, castes and creeds.
This is now a substitution for section 8 that I've read out to your lordships. University, creed, caste or class, and it shall not be lawful for the university to adopt or impose on any person any test whatsoever of religious belief or profession in order to entitle them to be admitted therein as a teacher or student. What was section 9 and?
Education. People will do. This is provisional 9.
Your lordship reads section 5. Aziz Bhasha is right in saying that these were to bring the statute in conformity with 28, my lord, and 29 too. So that's the change that is made in section 5. Then I'll take your lordship to section 8.
29. Section 6.
6 में क्या कुछ नहीं है.
Deletes 9, na?
Hmm.
Section 6 deletes 9.
If there is any provision which, there's just, you can tell us so that we'll read that as well. Yes, section 8.
What is section 9?
Section 9 was compulsory instruction, na, which was
9. That is, my lord, section 6, my lord, it deletes the compulsory education part. And this is again consistent of religious education.
Completely omitted.
Then, next one.
the word code. Section 10. Section 10.
10 is important. Section 10. For the words Lord Rector, wherever they occur, the word visitor shall be substituted. So, my lord, the visitor's power is there in every statute, my lord, whether it is a minority statute or otherwise. Then, now, my lord, section 14,
Just read the,
In no act, my lord, in any other act of university, the visitor has power to approve, amend, etc. the statutes and ordinances.
It is there in Central University, my learned friend is wrong.
State universities talk about it.
Talking about Central University. It is
This is not a central university. This is not a central university. This is not central.
Lord, when I was president of the Cambridge Union Society, my lord, we followed the rules of parliament, which was somebody gets up, I accept his intervention or I don't accept his intervention. I don't accept that intervention, my lord, for reasons stated by Mr. Sibal. Karan Thapar goes on and on. Why didn't we are the only father and son, my lord, who were presidents. Just as an aside, my lord. Now, my lord.
Becomes executive council.
Right.
In the and for the word post.
Right, section 10B, as Mr. Sibbal said.
Yes, that's right.
Becomes,
For the word court, wherever it occurs,
Executive.
the executive council. And there is in 10, my lord, in C, the visitor shall in every case give notice to the university of his intention to cause an inspection or inquiry to be made, and the university shall be entitled to appoint a representative who shall have the right to be present and be heard. Now, this brings in a very important element. Then,
Just to clarify, in section 10, court is started as executive council only for the purposes of section.
that's right.
Just to.
No, that's important, only for the purpose.
so it says for the word, right, in section 13.
Only with respect to 30, not otherwise.
I accept that intervention, my lord.
Guru's intervention has to be accepted.
Now, my lord, section 11, my lord,
This happens in parliament also, Millets, because somebody gets up and the person who is speaking, Millets, says, please yield. And I have to decide whether I yield, or whether I yield or not, or I don't allow.
perhaps your lordship can be a little more lax, my lord, in court.
If you don't yield, Millets, you cannot enter.
Oh.
But nowadays, shouting goes on, so that.
Now, my lord, section 14.
Section 14 is the visiting board, Chitta and City.
Now, my lord, there was a visiting board in section 14. I'm instructed that board never met. And therefore, my lord, that provision for a visiting board, which was an extra, has been deleted by section 11. Then, my lord, certain substitutions, because the governor, my lord, then becomes the chief rector.
Chief rector.
And
governor.
that is in section 12. So these are machinery provisions to bring things in line with the constitution.
It says successors of the first vice chancellor to be appointed in accordance with the statutes.
11. और क्या?
In section 17, proviso is deleted, no?
Important part, my lord. 17, the proviso was deleted in section 23. And Basa says that in effect in this statute, there was no substantial change that was made. Those.
But Dr. Dhawan, would the deletion of the proviso to section 23 not be a very important change? Because until then, no person could be a member of the court in law unless they were Muslims.
Right.
Now, post 1951, the requirement of having a Muslim as a member of the court is completely done away with.
Except, my lord, that I've already shown to your lordships that many of the members of the court had, by virtue of phase 1, necessarily had to be Muslim. This is removed in phase 2.
That's in phase 2 that is removed.
That's right. Now, my lord.
This is because if, we proceed on the basis that the court was a supreme executive authority, and post 1951, therefore, the membership of the supreme executive authority is no longer defined by religion. You could be a member of any religion to be a member of the court.
That, my lord, is a consequential amendment from the Constitution.
No, not necessarily. You may still have, even today, you may have a managing committee of, say, an educational institution where the entirety of the managing committee consists of Parsi Zoroastrians, Christians,
Yes.
Muslims, or whatever.
So this is significant, my lord. I'm not saying
that
it's
is significant. We'll have to.
And we were right, my lord. Your lordship was right in going into the statute itself. No? Section 19. Is the power to make statutes which will provide for the constitution, power and duties of the authorities of the university, which I've indicated already, my lord, earlier. Election and continuance in office of members of the said authorities, that's a continuation clause, including the continuation in office of the first members and the filling of vacancies of members and all other matters related to those authorities for which it may be necessary or desirable to provide. The rest, my lord, are not important, except section 20.
Where 20 subsection 6 now says, any amendment to a statute or a new statute requires the previous approval of the visitors.
Yes. So this happens, it is inherent, my lord, in the nature of the visitor's powers. That's the powers of inspection and otherwise. Now, my lord, we come to 20, section 20. Subsection 2, my lord. The court may from time to time make new or additional statutes or may amend the repeal of the statutes in a manner indicated herein. So, my lord, the court comes back and may from time to time make new and additional statutes or may amend the statutes, and the procedure is that the Executive Council will propose. And then finally, my lord, in subsection 4, the court may approve any such draft as referred to in subsection 3 and pass the statute or reject it. So the court's power, my lord, to that extent are there, my lord, in substituting section 28, and the court's power, my lord, are certainly there as far as the statutes are concerned. I don't think there's anything more. Let me take your lordship to the 65 Act, if I may, my lord.
Subsection 4, there's
Just
an
one-
appellate power given to the central government. On the statutes, if there's a difference between the.
Yes. So, my lord, all that happens is in accordance with the Constitution. That's one part, my lord. And the second part, the court's powers are made subject to, as the rector's powers or the visitor's powers are made subject to the court. And then, my lord, court eventually has to approve that, my lord. I've already pointed that out.
21(7), the visitor can suspend the operation of any, so 21(6) and 7 may suspend any ordinance.
Power of repeal.
My lord, this is a backup power in the visitor and with many variations, my lord. The proviso, my lord, to subsection 4 is provided that if the ordinance is not approved by the court at such meeting, it shall cease to have effect. That is section 4.
25A, the auditors are no longer now appointed by the visiting board, but by the Comptroller and Auditor General of India.
Yes.
See section 25.
Not here.
Yes, it's 15 only.
Now, section 24, my lord. I'm making a distinction, my lord, between the internal administration, in whose hands it is, and the external, my lord, supervisory or other powers, as the case may be. So, my lord, if your lordships were to look at, your lordship was on 25, the auditors. The Comptroller General comes in, my lord, which is a salutary provision.
And in this 1965 Act, somehow missed that actually.
President of India.
Which provision?
In the 65 Act, my lord, what happens is this function becomes advisory.
But how, where is the expression visitor defined in the 65 Act? Actually, I was just checking that out.
51 Act, my lord?
No, we are now on the, we are on the 51 Act, sorry.
Yeah.
How is the expression visitor defined? Somehow or the other, I just seem to have missed that actually. I was looking.
Section 13 minutes.
Section 13. Section 10.
Yes. The Lord Rector, wherever they appear, the word visitor shall be substituted.
But how, no, but who is the visitor?
Governor.
The Governor General.
Where do we get that?
The Governor is substituted, my lord.
Even section 13, Governor General becomes the President of India.
Right, section 10 says visitor is substituted for Lord Rector for the purpose of section 13.
Yes.
Then section 12, Governor of UP becomes the Chief Rector. But where do we have in this 1951 Act, who is the visitor? There must be some provision defining us, defining, who is a visitor.
Who is the visitor? Just give me a
I
moment.
was checking whether, there is an amendment to the,
Originally, it was the Governor General, but then as soon as we became independent, but the President.
Governor General was the Lord Rector.
That's right.
Though the Act used the expression both Lord Rector and Governor General in Council separately.
Because
Right. And then comes
the
in.
Rector was changed, but the Governor General became the President. The Governor General, the President of India took over the function of the Governor General.
Right, under the Constitution.
Yeah.
That must have been
That's
under,
what
under Article 370 or something.
Yes, exactly.
But,
they must have-
372, sorry. But what about the visitor, and who is to be the visitor in this act? Unless there's a casus omissus there.
Section 13. Who's the visitor? That's the.
No, the word visitor would have been still defined somewhere.
Somewhere.
It cannot be. This cannot be.
Find the original section 13 minutes will make it clear. Volume 3.
Yeah, we have that opened actually.
Original section 13. Have a look at that.
Because, my lord, the Lord Rector under section 10, the word visitor shall be substituted.
Who's the visitor?
Therefore, the two, it's a matter of substitution.
Okay, so what happened was the president became became the governor general, and because of the Lord Rector got substituted
Yes,
by
sir.
visitor there, that's all.
And this is all to bring things in conformity with the constitution.
Oh, right, because actually it was, right, the precedent, because we got that now at page 45 of volume 3G. That's where, you know, because that's the 1920 Act as amended. And there's a footnote that, you know, that section 13 of the erstwhile Act was amended by section 10 of the 1951 Act so that the President of India became the visitor.
And that would be, my lord,
If your lordship looks at page
Of?
of this PG, give some clarity. The Governor General shall be the Lord Rector of the University. And that's,
That's,
so the Governor General became the President and the Lord Rector became the Visitor.
right.
That's what. Hope that's clear.
that is in 10, my lord. That rector became visitor.
That's how.
To define the
Yeah.
word.
65 Act.
Visitor.
The concept PDF.
Now the President is the Visitor as the Act is on today, as on today.
That has happened.
That's at page 45 of the same volume. Now the President shall be the Visitor of the University. That's 13.
The general got substituted for president, T1 Act,
Correct.
and when with the constitution itself, and 51 Act says Lord Rector will be now read as visitor.
That's correct.
So the circle is complete.
Then now the Visitor is the President. That's how it is.
Because we substituted Lord Rector with visitor, the president becomes victor.
The
Well,
President
the
should be the visitor of the.
This is PDF. Which Right. Now, my lord, the 65 Act you find in the same volume at 99.
Right.
The important section here, my lord, is section 2, my lord, which changed section 23.
Where do we get the 65 Act now?
My lord, PDF 99.
Of this, of volume?
4A, my lord, same volume.
Yes.
Oh, templates will be omitted. Well, I'm taking your lordships to section 2 of that 23 is substituted. And the important, my lord, section is, my lord, B. For subsections 2 and 3, the functions of the court shall be to advise the visitor in respect of any matter which may be referred to the court for advice, to advise any other authority in respect of any matter which may be referred to the court for advice, to perform such other functions, such other duties, and exercise such powers as may be assigned to the visitor. So, my lord, it becomes a big change that is made. Our submission, my lord, on this would be, once you have decided the question of established by a statute, then everything else, my lord. But had that not been decided, that part of the statute part, these should have been struck down. Because they're quite clearly invasive. But of course, this is the precursor to this was.
Mr. Dhawan, then you are accepting that.
On de jure, we come to
No, that's something separate. De jure, it was certainly diluted, if not withdrawn.
what I'm saying,
When
what
you
I'm
argue
saying,
and say it should be struck down, you're accepting that.
my lord, what I'm saying is, my lord, had the Ajiz Bhasha, the ratio of Ajiz Bhasha is statutory intervention removes the. Had that not been decided and had they gone into these questions, these invasive provisions would have been struck down. That's what I'm saying. And of course, there is a restoration, my lord, where I'll just come to.
But Dr. Dhawan, now we are operating today 65 amendment has been made 35 and now 24, that is 59, 60 years ago. Do we strike down that amendment after the lapse of 60 years?
No, Lord, I'm saying you could not have struck it down because of the alternative ratio.
Basha said it was not established by a Muslim minority
Because
because
of
it
the
was
statute.
established by statute.
Statutory intervention.
Once establishment goes away for
Yeah.
Basha, it says it's not an MEI institution.
No, that's right, my lord.
Right.
I'm only saying.
So what you are saying is
Had the,
Basha
if your lordship were to hold
it is
that the
established.
statutory intervention part of Bhasha is incorrect, then some of these provisions are invasive.
So which means we'll have to strike them down today.
No,
To uphold
not-
their argument.
I'm not merely making
Dr.
the.
Devan, I'll tell you why. Unless we strike down those provisions now, these provisions still operate on the statute book.
Of course they do.
Yes, of course, because even only changes the preamble and.
Exactly, by
amended in 81 and the old position is restored, please.
1 second. Bol do. I accept your intervention.
What's the, all.
Just what to.
My lord, I'm not asking your lordship to strike it down now, my lord. I'm just saying
We recorded
that this
that.
is a logical consequence.
We record that submission on behalf. And when we were arguing for the first, that you're not asking for striking down of 1951
Right.
and 65.
I'm saying it would have been an alternative had the ratio been.
But even if we say that in your, let's assume everything in your favor, that we hold that Basha is wrongly decided.
On question of establishment.
Yes,
Even so, on the question of establishment,
yes.
right? Even so, the amendments which are made in 65, they don't get obliterated from the statute book merely because we say that Basha is wrong. Because that's an independent exercise of Parliament's legislative power.
Yeah, fair enough.
So we will have to say, therefore, now look at the problem in our part. We will have to then say that because Basha is wrongly decided on establishment, there was a challenge to the constitutional validity of the 1951 and 1965 amendment before
It wasn't
Basha,
decided.
which was not decided. Now we have to decide it today in the absence of really any challenge. That means those amendments of 1951 and 65 continue to hold the field today.
So that is what.
My lord, the point is, my lord, I'm sorry.
In that, even if we accept that in 1981,
So 81 they go.
some restoration, partial or full.
Not some, my lord, a radical.
Okay, okay. Partial or full, I say.
Yes,
That's something separate. But from 1965 or from 1965 to 81, it was not a minority institution.
My lord, I've said that. There are problems in that particular phase. I've indicated that. But, my lord,
Can that be then restored?
my lord, for that, no, for that period, of course, your lordship will look at the de facto argument, my lord, but at this point in time, the reason why I put it in phases, my lord, was precisely because apart from this glitch that existed in 65, I've mentioned that the restoration then comes in 81, which I'll just show to you.
So your argument is because of the restoration, it came back.
That's right.
Read your argument.
And my lord, your lordship will bear one thing in mind.
And significantly, the 81 amendment, when in Parliament this question is specifically raised, that you have merely done a facial amendment by saying established and deleting established and changing the definition of university. But you have not done anything to change the basis in the sense that you have not amended,
I'll take your lordship to 81.
Administrative provisions.
My lord,
That's what Banatwala said,
three
Brother Dipankar said.
provisions, my lord, are facial in nature. That's the preamble, my lord, 2L and 52C. Assume, my lord, that they're not there. The rest of the 81 Act, my lord, also makes restorative provisions, which I'll show to your lordship.
So 65 law, the Act of 65 continues to hold the field between 1965 and 1981.
My lord,
71.
72 Parliament brings another amendment.
Now let's see the 72 amendment. We have seen now the 65 Act.
we've shown the 65 Act.
65, anything apart from this that we have to see?
72, I've already indicated to your lordships, my lord. My lord, just kindly come to PDF 107.
That's the 72 amendment.
Okay.
Respect minutes.
I think our arguments about the court.
This is page 102.
20 of you that is interesting for me. Why? 502.